Go. And I think the transcript is going. Cool. All right. Good. We should be running at this point. And can everybody see the current draft that's up on the screen? I can't really tell if I'm sharing correctly sometimes. Okay. So couple of things. Yeah, Dawn, I'm not sure whether you guys can edit directly in. Sharing it this way was awesome. Great comments. And we'll go through those as well. Holly asked a great question before we turned on the recording about whether these standards will apply across the board to all attorneys, even if they're already currently certified. And the answer is yes-ish, caveat. I don't know if we're going to technically call it a grandfathering process or whether we're going to call it something different, but we know that there is a likelihood we'll need to at least provisionally certify people at the beginning, to who are already certified, and then give them some time to maybe meet the explicit criteria, which shouldn't be difficult for people who are already. I don't know exactly what that's going to look like, but we know there's this gray area, and I don't think we're looking to kick anybody who's currently practicing out. I don't think that's the intent. So
that might cause other problems.
yeah, I mean, there's like so many attorneys. We can absolutely afford to just kick everyone out.
Like possibly a defense work stoppage.
Oh,
oh,
yeah. I'm gonna refrain from comment, though I know what article you're referring to.
So Holly, it's the new DA in Multnomah County said there's not a public defense crisis. It's a defense attorney work stoppage. That's how he decided to start his tenure, by throwing that out there.
Well, and
be on the lookout for more. Be on the lookout for other articles that might have more accurate information.
I think that's coming from the DA's Association, actually. I mean, that's sort of in general what the theme has been from other DAs around the state, is my understanding. So anyway, but thanks for the clarification for those of us not in the metro area. So
okay. One other big piece of news. I spoke with Shannon today. We are going to drop work on the adoption standards. We don't have adoption standards currently. And given that it sounded like, I know this was the one that I missed, but it sounded like the bulk of the consensus was we probably need some other more experienced people in that realm to weigh in. We're just going to go ahead and push creation of adoption standards back. We've got another set for like capital offenses and stuff like that we'll be dealing with later. So we're not gonna worry about that right now. Is kind of what the direction we're going. So we don't need to worry about finalizing anything on the adoption standards. Before we get started, do we have, what other questions do folk have? Cool. All right. Dawn, I'm just going to start off with the notes that you sent in because they're great. It does say, so dependency 1, and I think we're going to end up with calling this dependency attorney 1. So I'll throw that in here now. Just because we're doing a thing with the naming. It is intended to cover child representation. I anticipated that was included under representing eligible parties, and then differentiating out explicitly that it would also serve for folk serving as a guardian ad litem for parent clients. So
I misread that.
Okay.
I must have misread that and saw that said eligible parents and not part. Just my bad.
No worries. Um, to the point with this overall structure, and this was just something that when I was going back through and reviewing the last work session, um, there's I want to say that I really heard, and I think it was Karen's commentary about needing to be able to get people in the door. And so like I was thinking about this while I was actually writing the draft and wondered, is there a lower step? Like, do we want to have something that isn't a truly more like a more explicit introductory level that relies heavily on mentorship? Um, that and so that when you and here's where like I like the idea, but it does introduce an issue on the other end of, well, then if you are fully qualified for dependency, you probably already have the experience to be qualified for TPR. So why do we have two? Right? So I don't know that there's a right answer here. And that's kind of what I'm wanting to get feedback is, do we want an like an explicit early tier? Or do we want to have something similar to what we have now, which is there's fully qualified for dependency. And if you don't meet those, then you get certified under supervision like we do right now. It's just we have much more clear benchmarks for what we're looking for that supervision to fill in or that mentorship to fill in until you're fully certified. And I want to open up the floor for the discussion on that.
So Kevin, I just want to chime in. I think a termination trial is a whole different kettle of fish than representing people on dependencies. And so I think that I see Jennifer put second option, and I kind of like that too. I think that we need to I have lawyers that work in my firm and I let them independently represent people. I don't follow them along and watch every hearing for reviews and even jurisdictional trials. But at TPRs, uh, when they do their first TPR, I am with them in the courtroom at counsel table. So I think they're two different things.
Okay. And Jennifer, when you say second option, do you mean keep the structure as we have it now and just do the with supervision for folk who haven't met all of the dependency criteria? Is that what you're meaning?
It was the one where if we're qualified for dependency, you're qualified all the way through for TPRs. But if you don't get that, then it's the provisional with the someone being able to watch you for those things that we feel need more help, like the TPRs.
Okay. So, okay, maybe I'm not following then. So you want what is that what we have now, or are you looking for something to change?
Sorry, when you were laying out the two options in the beginning, and I am driving home from preschool with my kid, so forgive my scattered brain.
Fair enough.
My initial reaction was there were two options, and one was like, so we have these two tiers and you have to meet these two tiers, but the other was that it was if you're certified to practice juvenile dependency, you can take the case the entire way through. And if you don't meet the ability to take the case the entire way through, then you would be, I think you called it like provisionally certified or something like that, where you still needed some level of supervision. That one made more sense to me.
Yeah. We can also break it into 3-tier. Like we can have it as a 3-tiered where you've got the entry level, highly supervised and mentored attorney. You've got you're fully dependency certified as a 2nd tier, and then TPR is another step beyond that. I would also tend to agree that TPR trials are a vastly different beast. Same, like I never handled a permanent guardianship trial, but I would imagine that they are akin to a TPR trial with just like the snidgiest lower level of risk. So I personally, I would prefer to have TPR continue to be a separate level. But whether it's 2 or 3 levels, that, I mean,
Maybe this is beyond the scope of this work group, but as you start talking about different levels, and I am a supervisor and I think like this, okay, I come in and I get certified to get in the door. OPDS going to fund me one way, and then someone who's certified at the highest of highest levels is funded a different way. So it's envisioning a whole different funding structure too for every office, right? Because right now it's an FTE. Maybe it's way more in the weeds, right?
so
And tell me that if that's true, but I'm like trying to think of like what are you, do we want to create something that's not going to be workable?
no, right. That is one of the other things, is that we need this to be workable. To the fundings, like, I do want to say that I don't know that we can expect that the way that things are funded now will carry through. I honestly, at this moment, can't say I have a really strong idea of how things are going to be funded in 6 months. I mean, when we get to the next contract, I'm not sure that what we have now is going to stay the same. There's a lot of discussion going on with that. I'm not in those discussions, but I know that they're happening. So I wouldn't assume that the way things are funded right now will necessarily carry through. And I do know that in let's see, I think dependency and TPR are both currently either attorney 3 or attorney 4 level compensation. But I'm pretty sure they're the same, regardless of the qualification level. So that I don't know that
They're at the no, they're dependencies at second tier.
Is it? Okay,
No,
I maybe
it's third. It's third.
I'm sorry, it's like the second from the highest. I don't know
Yeah.
if it's like the mock scale or which scale it is,
Yeah.
but it's second
Yeah.
from highest.
okay.
And
I know
that's not included. That's not the PCRP structure, like, right?
Correct.
So my
PCRP,
brain,
yeah, PCRP and juvenile contracts do it differently. So we also don't want to necessarily tie funding level to qualification level. I don't, like, for one thing, that's no difference in for hourly attorneys, right? Hourly attorneys, the funding level is by the type of case, not what their qualification level is. So we're trying to keep that as a separate conversation.
But shouldn't it, Kevin? Oh, never mind if it's a separate conversation, because I was gonna say, shouldn't it be the level of experience? Because someone with Dawn's experience, for example, can do something 10 times faster, and she's not gonna bill you as many hours as someone, who has less experience. So that's something just for y'all to be thinking about. If that's a different
Yep.
conversation, we don't have to get into it today.
Yeah, I think that
Yeah,
the
but the other
unfortunate thing.
thing to
Sorry,
I was
go
just
ahead,
going to say
Jennifer.
the other thing to think about is that if we've got these set out as different tiers, if my rate of pay doesn't change between the first tier and the second tier, why would I ever do the extra stuff to get to the second tier?
Yeah,
And-
it's like in
I mean-
criminal law, I'm gonna do them misdemeanors. I'm not gonna do them, class A felonies if I got paid the same. It's the same concept.
And I know that
Well, but
a lot.
I think it's a little different though, because I mean, none of us do this with this idea that like, oh, I'm going to most people don't do this work because they're trying to maximize their compensation. They're going to want to be TPR qualified because if they have a dependency that goes through to a TPR, most people aren't going to want to abandon their client.
I don't know. It depends on the client.
So
Honestly.
I'm gonna step in here and kind of tamp down on that. This isn't really the focus for the funding model, and the tying to compensation isn't the focus of this work group. I will say, there are a lot of comments on this exact subject that we are talking about internally I don't know that I've heard anything new, but importantly also, when we get to the discussions about funding, these are the types of things that should be brought to the commission. These are the types of things that would be appropriate for public comment when the commission is discussing funding models and things like that. So our focus, unfortunately, is more specific to, unfortunately isn't the right word. Our focus is more specific to what should those qualifications look like.
But really, truly, we just want to make sure that people that work for people who can't afford lawyers have the right level of qualification, right? Unlike people who hire, you can go hire anybody to work for you. And sadly, that happens, right? When people have the resources to moderately income families hire people who aren't qualified. Our goal really is just to make sure we have the right level of qualification for the complexity of this work.
Right.
I do think, though, that if we are suggesting a pathway for qualification that includes mentorship, that we need to make sure that there is a pool of those people that are in some way receiving some level of compensation for that. And I know the compensation aspect, but there needs to be a mechanism for that mentorship to occur if we're suggesting that that be a way for someone to be qualified. Does that make sense?
And yes, 100%. I like that is what we're internally advocating for as well, is we need, if we're going to make this system work, and I will be clear, like dependency is one of the areas where I personally don't see it working without adequately funded and worked mentors or a very robust training a process for new entrants. It just like we need that to be available, and that is being advocated for. So okay, are there any comments on like a dependency 0 level, or I mean shift everything down and we got 1, 2, 3, or because it sounds like the consensus is more let's keep TPR separate. It deserves its own level, but do we want something that is like, we know you're not qualified independently to do this, but we have a certification level to get you in the door? That is not something that exists in any of the other areas. There's no criminal level 0, but it's also really easy to meet criminal level 1.
My thoughts are this. It's pretty easy to meet dependency level 1, 2. And what you're describing is a certified law student or
SPPE, right? Like that's the other possibility.
Or yeah, given what I know from grading the SPPEs, an SPPE, or something else. I don't think we should go lower, because remember, your entry level got a shingle out. I passed the bar, I hung a shingle. Can I get myself up to speed with a little bit of motivation to do this?
But Dawn, have every one of your has every one of your new hires in the last 5 years come in with, I've done these hearings?
I think that there's options, and we've been lucky in the last few. I mean, I'm not looking at the details, but my recollection is we hired people that were motivated to do this work and were CLSs or did something. Law school, I mean, I went to law school a long time ago, but nowadays there's more hands-on, practical stuff that could support it. And I think maybe one of my comments, I'm not sure, but I'll make the comment now, is I'm hoping that there's going to be some like escape valve for the rare person who comes in and says, look, I went to a law school that had a bunch of clinics and I did all these clinics. So some of these things here, I should be able to use this to show I meet the qualification, even though it's not listed. Because that's what the other samples have.
I would agree that, and some of, keep in mind the way that we've structured this, there are going to be pieces that you might meet, other pieces like components that you don't. Your mentorship, such as it's going to be, is focused on let's fill in the gaps that we've got, get you fully certified, and then you're independent. Jennifer?
I guess I'm not understanding then that the distinction between going to a lower level under mentorship versus this level under mentorship. I don't understand the distinction.
That it may
Either
be a
way.
distinction without a difference. And like it was just something that I was thinking of when so if it doesn't sound like it fits, I'm okay being wrong, and we can just move forward with what we've got.
No, I mean, I think it's important to have that mentorship option. I mean, I don't know the qualifications of the people we've hired in the last 5 years, but I'm sure there's somebody that hasn't done all of these things. Hell, I probably didn't do all of those things a million
Okay.
years ago.
So sounds like we've reached relative consensus that the structure we have, we like, and we're going to stay with. Okay, I'm seeing nodding heads. Cool. Okay. The comment on agreeing to abide by the rules of professional conduct, that was more of an internal comment, but no worries, Dawn. One thing I don't know, we may have an actual explicit, hey, any attorney doing any work for us set of qualifications. And the abiding by the ORPCs might be part of that. So in any case, that was more of a, do I actually need to keep this in this document thing? Any additional requirements for out-of-state practice? Thoughts on this? One of the things that I'm not sure that we, meaning OPDC, can adequately do is assess how similar our juvenile code is to the juvenile code of other states. Because there's a lot of variation in how things are practiced. There may be some stuff that doesn't matter what the differences are. There may be some stuff that it really and truly does. And we don't practice it. I don't practice in any other state. I'm not licensed in any other state. So I don't know that I could adequately identify whether there are meaningful differences, such that we would need somebody to do training. Or instead, if we can simply say, here's what Oregon law requires, show that you know how to use it. That's the way I was framing this particular thing. What are people's thoughts on how this might apply for people coming in from elsewhere?
Could you have there are just a few basics, and I think my comment kind of encompassed it, the obvious ones that I'm aware of. Could you have like a even if it were just 3 questions in your state? Do parents get attorneys even if the children are not removed, right? Because there's the statutory standard for appointment the constitutional standard for appointment, and I think Sandowski or something like the due processy one. And definitely for terminations, and then if they're significantly interfering with your access to your child one, and then there's statutory, which more states are moving towards, but Oregon uses, right? So you can have like 3 questions. Do children get lawyers in your state, right? If not, then we might have to provide a little more information about why.
Well, Dawn, I think that child representation is the potentially particularly troubling one, because I know in other states, they get guardian ad litems who advocate kind of like a CASA would advocate. They don't advocate for the child's wishes. And some attorneys, even in Oregon, are still going by that kind of old standard that's like, oh, I'm going to substitute my judgment because the kid is like 7 or whatever. And so it's even changed in the state of Oregon. I'm old. And so I know I look like I'm just a spring chicken, but I'm very old. And so I remember that. And I work with a lot of lawyers who do that. And so I think that to me is, I like your idea of questions. I like your idea a lot, but we need to make sure if we're appointing to children that they have someone who's going by Oregon statutes.
this is something that we would likely workshop internally as to what those questions would be. It may be a component of a dependency training that is developed, like take the final test. You pass, you're good, right? If you don't, maybe take the training and then reassess, something like that. But okay.
So I guess, sorry, my question about that though is if you've been practicing in another jurisdiction for a year, presumably you also know how to research the statutory authority. You're also having to review the specific standards for representation and dependency cases, which covers the substituted judgment best interest issue. I guess I just don't know that we need to create more barriers to qualification by having someone take a test about it. Couldn't there be like a document, like these are the critical pieces, or could there be like, I don't know, some other mechanism? Because I don't know, a test of some sort just doesn't seem like it's that level of necessity to me.
And I agree. I hear what Melissa's saying, where I go back to this single shingle, Kevin, idea that you presented in the very beginning. Like I work for a not-for-profit, and we have a little test. It's called We Interview the People. You delegate to us to hire the people, right? So, Public Defense Commission delegates to MPD to hire the people, right? Because you contract with us.
Right.
But if you're contracting independently, I'm envisioning the test might be someone from your office chats with them about that. Whether it's I would hope it would be a real chat and not a written test, but this is a big state. And you guys are based in Salem.
If we do adopt what Massachusetts has as part of its model, which is the regional supervising attorneys, that may be part of that process, is having an introductory chat with the regional supervising attorney for whatever area, and that could be part of it. That's okay.
Well, and I mean, I don't really know. I mean, how this is relevant to the standards, because this is what happens right now. So we fill out questionnaires for OPDC. We've done it for years. We say what we've done. There's questions on there that ask us, like I have had multiple lawyers come from out of state that I've been able to get certified. Yep. And OPDC says back to me, well, we feel more comfortable. They've only been here a short period of time, with them being mentored, supervised essentially for the next few months. They ask questions on writing samples. So all of this behind the scenes stuff is not the standards. Like the standards are the standards. So if somebody submits their application to be certified and they're from another state, OPDC is going to vet them because they vet them now. So I don't think we have to put all of this in writing, right? I mean, we're just talking about what's the standards.
Good point.
Yep, that's fair. Okay. I know there's and just to the point of mentorship, there's a lot we have not yet defined about what that's going to look like. Hopefully that will be defined more as we get there. When drafting the and this was not Dawn, you weren't the only person who commented on this. Under litigation, we have an attorney may demonstrate this core competency by listing 4 case numbers. Comment came in that one, case numbers is not used across the board for all of the different qualification standards that are being developed. Some are using the word clients instead. Do we want to shift to that? And the issue here that I had is that not all of the things that we have here may have case numbers. Dawn, you're saying that administrative hearings may have case numbers.
There's some kind of tracking system. I don't do many of them.
I don't know it either. So I don't know if I don't know how ubiquitous that is, such that we could rely on it for the wide number. And it may be that we just ask the question in a way that says, hey, tell us about the, something, so that we know that you've done this. But I do want to flag that we may not end up, it may be changed to clients or something along those lines. I'm not 100% positive.
Well, and case numbers, sorry, Kevin, but case numbers, you could represent one client in 4 case numbers where you're litigating the same exact issue because there's 4 kids.
Yeah.
So like so I think lawyers are really good at parsing some of that out. And so if we need to be clear about what we're intending.
That is a good point. I had not considered, yes, if you've got 4 siblings, that's technically 4 case numbers. And then, I mean, if you're doing an adjudication on the merits, it's just 2 siblings and that's all you need. Okay. And even if you're the one representing the kids, then even just representing 2 clients, 2 kids, 1 adjudication would get you there, which is not the intent.
Would it be hearings?
For unrelated case numbers? For unrelated clients?
Yeah.
Why say number of cases or clients or substantive issues or areas or like something like that? Because really what you want to know is that they've been into court on different kinds of matters and and thought on their feet and interactive.
I like matters, actually. I think it's broad enough to cover a variety of things. And I don't know that you would necessarily consider different siblings in the same family as a different matter. I mean, there were circumstances where I might, but in those circumstances where I might consider them to be different matters, it's because the representation of the siblings is dramatically different. And that probably would fit our intent. What are everybody else's thoughts on that?
Well, and the intent here was also, this isn't just dependency. This is any like custody, complex civil litigation, right? So, yeah. So I think by using matters, and then you could also put in parentheses just to make it clear on the definition, like, must be unrelated clients, cases, et cetera, what have you. I mean.
Karen, I know you were trying to say something, but it sounded like you were cutting off. If you want to go ahead and give it another try.
I was going to say that instead of saying different matters, just say unrelated matters.
Yeah. Okay. 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 Cool. And then that solves that one, because we don't need case numbers if it's not an administrative. We're not using that. Okay.
Before we move on to that, when we say unrelated, my brain. So say I represent a young person. It's the same person, but they end up with a delinquency. Dependency. They end up with a delinquency case. I'm certified to do both, right? I litigate a motion to suppress on the delinquency case, and then I litigate a motion to let her get her ears pierced without her mother's permission on a dependency case. It's related because it's the same person, right? It's just a different, I went in on two different types of matters and litigated it through. So do we want to say unrelated or some, I think I would put that down even if I read that hypothetically and say, same client, completely different contextual litigations. And say, please consider. But if you say unrelated, you know, you could work for one person and do a lot of different kind of hot litigations.
That's true.
And isn't the intention to ensure that the person has litigation experience, like that they're getting that experience? So really we're concerned with the activities and the different types of activities that a person is engaged in, less than we are about what client it is for, right?
Okay.
So
I think I see where we're going with this, and I'm gonna take the language and I'll workshop it offline and try and work something. But the way I've got the subject of the sentence as matters is the problem. If I flip it to activities, that might work. Okay. I think I got where we're going on this. Okay. I don't want to skip any of the other notes that were. Nope. Okay. Oh, institutional representation. All right. I had it split out, and this is I had this split out, and I think if I remember right, I took this from the draft of the criminal qualification standards. 12 months if you're representing people, 18 months if you're representing institutions. How do people feel about that split of time?
What is it based on? I mean, you just been doing it more.
So
Yeah.
I mean, it was something that I drew inspiration from a different location. I don't know that it necessarily is the best applicability here. The one thing that I did pull that I thought they did a good job on is it's 12 months if you're doing at least half-time representation of individuals, right? So like if you're a lawyer, but 3/4 of your time is doing contracts negotiation and only 1/4 of time is actual litigation, I don't know that that's necessarily the best fit. Maybe it is. Maybe it's fine, right? In the criminal context, they had specified that it had to be public defense time. I don't know that that's necessarily equivalent here. I think representing clients in general is going to be the communication portion, and theirs wasn't tied specifically to communication. It was just, you have to have been representing public defense clients for this amount of time, and you got to do it for longer if you don't do as much public defense.
Well, I would agree with that. I mean, if a DOJ attorney were to come aboard, I think that that's a very different type of representation than we all do.
And that's why I put for if you're representing institutional clients, it's 18 months instead of only 12. You have to have the experience.
Right. No, I agree with that.
Okay.
Although I will just say DOJ still has to deal with individual DHS caseworkers and supervisors as like mini clients within the institution. So that might be slightly different.
I think a more
except they're slightly less praised than our clients. I mean, I think there's a difference between representing like a professional person that's working, and I know, caseworkers are all over the map, but I mean, I feel like representing humans who have been through a lot of trauma and whose kids have been removed is different than that.
And I think, Kevin, I think I captured that sentiment in my comment where I said, have skill communicating with lay witnesses, ordinary folks, similar to indigent case client base, right? That's the difference, I think, where
Mhm.
um, people that work in institutions, even though they're working with caseworker, at least went to college, and theoretically they're not impaired significantly by active mental illness or substance misuse disorder or behavioral problems, significant behavioral problems that make it
Well,
communication
and they're not there
difficult.
because their kids were taken away. I
Right.
mean, they're
Right.
there because they're there for their job as opposed to being in a trauma situation, regardless of background. I mean, it's different.
So this was the first attempt at drafting some language around what we might want to do to differentiate between institutional representation, how it relates to client communication, and actually working with actual clients. I mean,
You could say representation that is removed from working, from communicating with lay witnesses, ordinary folks, similar to indigent client base, and traumatized people.
I don't know that many DOJ folk would say that they're that far removed from it. They're kind like,
I get fair point, but workshop it.
yeah.
I don't have anything else.
Well, and that's kind of what my question here is. Are there other things that we want to look at that might work better than just a time differential? Or or do we want to add like a caveat that says if the time is spent working with institutional clients, then you must also do this additional thing. Like you must like there's the the CLE is a third way. I think 4 hours is pretty minimal to satisfy this whole requirement. But if we said if it's 18, you've got to spend 12 months if you represent individual clients, 18 months if you represent institutional, and 4 hours CLE on how to, be trauma informed, because DOJ, you don't know how to do that.
I mean, is there room for a combination of things? I mean, I guess it seems like when I think about this, 18 months versus 4 hours, like
Yeah.
that seems like a big difference.
I threw 4 hours in largely because I think that was what was noted in like Arizona or something. I'm not married to 4 hours. I think it's pretty minimal. I think if we're going to go a CLE route, and I'm not sure that if we're adding CLE here, 4 hours maybe would be enough for a training, which I think of as very, very different from a CLE.
What
But
about
that's
an
a
option?
big maybe.
What about an opportunity to demonstrate lived experience? Like, say, for example, you've got an attorney that works for an institution, but they have some kind of lived experience that has them communicating effectively with around the court settings with people that have been through a lot of trauma, right? There could, you know,
Well, I know
That
that there are
might end up,
people. Oh, sorry, go ahead.
I was just going to say that might end up with too much discretion on who thinks what kind of things qualify versus something that can be equitably applied across the board.
good point. But what if someone said I was a social worker before I went to law school and I worked at a drug treatment facility or a trauma hospital? I'd be
Then
like,
I
well,
would say
they
that
probably
qualifies
have
as
the
the,
skills.
I mean, that would qualify as the 12 months of experience engaged with individual clients. I mean, it doesn't say legal representation, court representation in
I love a
hearings.
room full of lawyers. Good point.
Yeah.
Maybe we just
Yeah.
say that the experience can't be with your own dysfunctional family. I don't know.
I guess I think it could it not be a combination of training and experience? Because there are also like law students who do practicums or have worked with people doing post-convict, like interviewing people for post-conviction relief, or that have quite a bit of experience communicating with clients,
So
but
what
it might not
about,
be on a full-time basis or a half-time basis.
yeah, I think we can look at the time component into how much time, but maybe just something instead of 12 months experience engaged in the representation of individual clients, but just whatever time we decide, practical experience engaged with indigent persons.
So, okay, so what if we had one, like the first criteria is that, like time spent working with indigent population, and then a second criteria that can be satisfied in multiple ways: 6 months representing individual clients, 12 months representing institutional clients, or training or something along those lines. So like the first one, and then the second is one of the following, A, B, C, or D.
I think that's getting very close. I think just saying indigent, I wouldn't want to use indigence as
Right.
the measure, because it's actually, there are a lot of indigent people that don't have the same limitations or that don't get their kids, that don't end up in dependency court, right, with the multi-layered problems, trauma, drugs, that kind of thing. So we need a different word besides just indigent.
Vulnerable populations.
Let's try this. 12 months experience working with teams.
Maybe vulnerable or trauma impacted or something.
Oh, I
Ooh.
like that.
Kevin, can we also clarify how mentorship fits into this?
Mhm.
Just thinking about, I see certification from an approved attorney mentor. I think about my office, for example, hiring somebody fresh out of law school, a supervisor mentor sits in with them for several client meetings, but isn't sitting in with them for a year or 6 months.
Right. And also, let's see. So,
And I think the same is true from what I've heard from Holly and Rebecca during this. Yeah.
yeah, no, I would agree. So my thought is that the certification from a mentor would be an independent way to certify this. Like, I sit in with somebody who's a new attorney, they're working with, they clearly get how to talk to our client base. I could send in that certification, and that gets held by OPDC. And when all of the certifications are in, you're approved, you're independently qualified. At the point where that certification comes in, the mentor doesn't necessarily need to keep sitting in on those conversations. They're there to maybe, check in. Hey, I'm having this difficult conversation with this client. Can you help me? That kind of thing, but doesn't necessarily need to be throughout the duration of this whole thing. I mean, that's how I would structure it, but and that's probably what I would advocate for. So,
That makes sense. Yeah.
I will workshop where to put this. We don't need that because that's in the first part. Okay. So that would be independent. Okay. I'm gonna get rid of the words CLE here. Transcripts maybe, or certificates. Indicating specific time spent working on how to communicate. I don't know that this fits anymore. Because if the goal is, because I feel like the goal is to have two components, knowing how to talk to the clients, but specifically knowing how to provide client advice, which is more the legal side of stuff, right? Does that make sense?
I think that piece about transcripts or certificates would be what I would bring with me to a meeting with this attorney mentor to show that I know how to talk to clients.
Yeah, that I can see that. What if it's
Can you
There's
fill
two-
me in when you say transcripts? Like literally, I've gone to a CLE and I
mean,
transcribed a recording of what.
no. Like the bar, if you go onto the bar website, they can give you the transcript of all the CLEs you've submitted.
Oh, like a school transcript.
Yeah.
Well, I put that comment. It was like, are you talking literally about transcribing someone talking?
I mean,
Yes.
Maybe it's evidence of having completed X,
yeah,
Y, or
no,
Z.
yeah. Transcripts is more of the short form I was thinking on there. Okay.
Did everybody else understand he meant like the bar transcript that says what I've attended?
What if we do this?
Had you just read an appellate brief or something, Don, or a decision? So you had that kind of transcript.
I will say I have been transcribing some body worn cameras and listening to them, like AI transcribing and reviewing. Maybe that's where my brain was.
Okay. What if you have 12 months experience working with the population, that will do it. That will satisfy part of the component. If you have specific training on how to communicate, that will instead qualify for that component. And in addition, we also want to know you know how to translate legal concepts for your client. So we need to have some amount of experience of representing clients. And preferably clients that are people. Is this like, hold on, maybe I can increase the size here and make it easier to read.
We can also zoom in on our computer screens. If you look at over it and hover, anyone can zoom in, which can be helpful.
I did not know that.
And you can also pop it out and look at it on a different screen if you have multiple screens.
I think people are thinking about this.
Am I the only one who doesn't know what we're supposed to be thinking about?
Right. You kind of lost me, Kevin.
Oh, I'm
I'm
sorry.
trying to like get where are we on this work through?
This structure.
Okay. C
Yeah.
from communication and interviewing. Okay. So we're still on the 12-month, and you're asking us to assess the modifications you've made. Okay.
Yeah. So if you're certified by an OPDC mentor, that's it. You're done. Right? Alternatively, two pieces. You have to show you can work with vulnerable populations, and you have to show you know how to do like client advice stuff where you actually translate legal concepts into a way a client can do it, right? For the vulnerable populations, you can either do it with experience or you can do it with the training. For explaining legal concepts, you gotta have been an attorney. You have to have represented people for a specific period of time. And if they're people, great. If they're not, do it longer.
I think the format language needs a little work, but the like content language looks very good.
I am perfectly happy to update format language to make things a little bit clearer. That works for me. Okay. Does everybody else feel the same? Cool.
Yes.
All right. We are at 6:00, so I want to be mindful of people's time. Let me double check if there was much more from mentors. To review documents. No. So down under utilization of core staff, the review of OPDC, this would be OPDC going and looking through the records that we have. Like if you've been using experts and core staff, we'll know, right? And we can just, all right, cool, we're good. You know how to use our systems. We're good. It's not something that we would expect the attorney to supply. It sounds like the consensus, and this is because I wasn't there, out of court advocacy is a performance standard, not a qualification standard. Does that sound like what everybody agreed, kind of conceptually agreed with last time? Cool. I will remove that from here. And I think that's the end of the comments. Oh, one last one. Whether 366 guardianships should be included in the definition of a dependency attorney one. I could go either way on this. I feel like the dependency process would normally include, at least the way we currently do things, it normally includes durable guardianship. But permanent guardianships we consider to be a whole different ball game. I think part of it is just that they were so rare until a couple of years ago that nobody was really thinking about them. So that said, go ahead.
No, sorry, I didn't mean to cut you off.
You're good. Okay, cool. Then I think we're in a good spot. I will work up a revision to the draft and send it out probably later this week. Please feel free to comment by email as well. This doesn't have to necessarily, like, comments don't all have to come in through the work group. That said, I know that y'all are busy, and if this is an easy way to provide feedback and commentary, we can continue to schedule. I don't know exactly what our deadline is at the moment. So I'm going to continue acting as if it's not now.
Hey, Kevin,
Yeah.
are you looking for attorneys that have done contested adoptions?
You weren't, so my apologies, you weren't here at the very beginning. And for others who weren't as well, I spoke with Shannon about this today. We are dropping work on the adoption standards. They don't happen regularly enough to be a big issue. We don't currently have standards for adoption. And we have other case types that we have put off to a later qualification standard review. So we are going to kick the can on adoption standards.
Which is fine. I'm just thinking that I know people, like besides I know a few attorneys
Yeah.
that do them, and I've done them, and some other people have, and I'm just, so like, I can start a list too, if that would be helpful.
If you could email me that would be great.
Sure.
I'd love it. And then I do know that we'll be kicking the can, but those names will be helpful when we
They're
find it
pretty
again.
rare. I mean,
Yeah.
I think I've done a handful in 20 years. So
The entire time I was down in Douglas County, I knew of one.
yeah.
So yeah. Okay.
Thanks.
I think we have a great stopping point. Thank you all. Very, very appreciative of your help. And I will reach out for when we're going to schedule the next one. But should have another revised draft for everybody to review later this week. All right. Thanks,
a lot,
everybody.
guys. Bye-bye. Have a good night.
Bye.
Thank you. Have a good night, all.